This is Remedial Law Review Part 2. So in this review, let us first talk about evidence. So evidence is admissible when it is first relevant to the issue, and second, it is not excluded by the rules of evidence. Again, evidence is admissible when first, it is relevant to the issue, and second, it is not excluded by the rules of evidence. However, let's take note that not all relevant matters are admissible in evidence. As a rule, collateral matters, even if relevant, are not admissible. As to form, evidence can either be real, documentary, or testimonial. Let's discuss each one. Real evidence. This is the evidence that which is addressed to the senses of the court, as where objects are exhibited for the personal observation of the judge. So take note, for real evidence, there is an observation of the judge. The object addresses to the senses of the court. As for documentary evidence, this consists of documents, depositions, and other papers presented before the court. And testimonial evidence, the key word here is orally. It is given orally by witnesses. So except as provided by the rules, all persons who can perceive and perceiving and can make known their perception to others, they can be witnesses. Again, except as provided by rules, all persons who can perceive and perceiving can make known their perception to others, they can be witnesses. Now, there are other forms of evidence. Evidence can be direct. It is direct when it tends to prove a fact without reference to any fact. Evidence can be circumstantial. That is when it tends to prove a fact by inference only. However, evidence can also be incompetent, and that is when the witness giving it lacks fitness to give evidence. Or it can be irrelevant when it has no connection with the point at issue. Evidence can also be immaterial when it would not affect the point at issue even if admitted. Evidence is also primary when it is the best proof that can be produced. Evidence is called secondary when it is proof admissible in the absence of primary evidence. Evidence is prima facie when it appears to be sufficient for the time being until something arises to controvert it. And evidence is conclusive when it establishes the fact sought to be proved without any further question. Now, there are certain matters on which evidence need not be presented. There are three things. These are three things. Number one, matters of judicial notice. Second, judicial admissions or the admissions made by the parties in the pleadings or in the course of the trial or other proceedings in the case otherwise, and these are known as judicial admissions. And finally, matters covered by legal presumptions. Again, there are certain matters on which evidence need not be presented, and these are judicial notices, judicial admissions, and legal presumptions. Now, matters which are deemed to be of judicial notice need no introduction for proof because these matters that are judicial notice are noted to be, number one, facts which are of public knowledge. And second, these are facts which are capable of unquestionable demonstration. And third, these are facts which ought to be known to judges because of the functions of the judges, existence and territorial extent of states, measures of time. These are facts which ought to be known to judges. So again, matters which are deemed to be of judicial notice, they don't need introduction of proof These are facts which are, number one, of public knowledge, second, capable of unquestionable demonstration, and third, facts which ought to be known to judges. In civil cases, the party bearing the burden of proof must establish his case by a preponderance of evidence. While in criminal case, the accused is entitled to an acquittal unless his guilt is established beyond reasonable doubt. So, again, the evidence for civil case, preponderance of evidence. Okay? The party bearing the burden of proof must establish his case that there is a preponderance of evidence. While in criminal case, the accused has to be acquitted unless his guilt is established beyond reasonable doubt. Otherwise, he has to be acquitted. Now, effective August 1 of 2001, the Supreme Court promulgated the rules on electronic evidence, which covers now electronic documents and electronic data messages. All are applicable to civil and criminal actions, as well as quasi-judicial and administrative cases pursuant to e-commercial law. So again, electronic documents, electronic data messages can now be used under the rules on electronic evidence. Now let us talk about special civil actions, provisional remedies, and special proceedings. What are special civil actions? Now, special civil actions by their nature require a different procedure from that of ordinary civil actions. That's why they're called special civil actions. Examples to this are interpleader, declaratory relief, certiorari, mandamus, quo warranto, expropriation, foreclosure of real estate mortgage, partition, forcible entry, and unlawful detainer and contempt. These follows special civil action. These are special civil actions and they have its own special procedure. How about provisional remedies or PROVREMs? Now, these are available for the preservation or protection of the rights or interest of parties during the pendency of the principal action. In other words, there is a case going on, and while these cases are going on, before judgment is made, there is a need to preserve or protect certain rights or interests of the parties. And so these remedies are in place to make sure while the main case is running, rights and interests are protected. These are what you call provisional remedies. So examples to these are your preliminary attachment, preliminary injunction, receivership, replevin, and support pendente elite. Okay? Now, all other remedies, including one to establish a status or right of a party or a particular fact, are called special proceedings. In other words, it doesn't follow the usual flow of a civil action, but there are special rules related to it. Now, rules of special proceedings are provided for in the following cases, like settlement of estates of deceased persons, allowance or disallowance of wills, letters testamentary, escheat proceedings, guardianship and custody of children, appointment of trustees, adoption, rescission, revocation of adoption, hospitalization of insane persons, habeas corpus, change of name, voluntary dissolution of corporations, judicial approval of voluntary recognition of minor natural children, constitution of families, declarations of absence, cancellation or correction of entries in the civil registry. These are all examples of special proceedings. Now, on October 28, 1997, Republic Act 8369, or otherwise known as Family Court Act, was signed into law. And under Section 5 of the Republic Act, the family courts are given exclusive jurisdiction to hear and decide on the following cases. So in other words, there are now cases very specific to be decided by family courts, and one of which is criminal cases where one or more of the accused is below 18 years old, but not less than 9. So between 9 to 18 years old, and it's a criminal case. Now, where one or more of the victim is a minor at the time of the commission of the offense. So it doesn't need to be both. One party could be the minor, or both could be the minor between 9 to 18 years old, provided that if the minor is found guilty, the court shall promulgate sentence and ascertain any civil liability which the accused may have incurred. And second, the sentence, however, shall be suspended without need of application pursuant to PD number 603, otherwise known as the Child and Youth Welfare Code. So in other words, now that it is in the family court, if in case the minor is found guilty, it will be the court that will ascertain that civil liabilities will also be promulgated, and at the same time, sentence shall be suspended pursuant to the Child and Youth Welfare Code. Now, the family courts are also going to hear and decide on the cases of petitions for guardianship, custody of children, habeas corpus, especially on matters like petitions for adoptions of children and revocation thereof, complaints for annulment of marriage, declaration of the nullity of marriage and those relating to marital status, property relations of husband and wife, and those living together under different status, agreements and petitions for dissolutions of conjugal partnerships of gains. The court also hears petitions for support and acknowledgement, as well as summary judicial proceedings brought under the provisions of Executive Number 209, otherwise known as the Family Code of the Philippines. Family courts also hear petitions for declaration of status of children as abandoned, dependent, neglected children, petitions for voluntary or involuntary commitment of children, the suspension, termination, or restoration of parental authority, and other cases cognizable under PD number 603 and other related laws. Family court also take charge of petitions for the constitution of family home, for cases against minors under the Dangerous Drug Act, or the violations of RA 7610, otherwise known as the Special Protection of Children Against Child Abuse, Exploitation, and Discrimination Act, as amended by RA 7658. Cases of domestic violence against women and children are also taken up in the family court. Now, pursuant to Section 13 of the Family Court Act, the Supreme Court constituted a Committee on Revision on the Rules of Court, chaired by Senior Associate Renato Puno, and to date, the Supreme Court has promulgated the following rules, such as rule on the examination of a child witness, rule on juveniles in conflict with the law, rule on declaration of absolute nullity of void marriages and annulment of voidable marriages, rule on legal separation and on provisional orders, rule on custody of minors and writ of habeas corpus in relation to custody of minors, rule on guardianship of minors, on adoption, on violence against women and children, and rule on commitment of children. Now, one of the innovative strategies of the Supreme Court in decongesting caseloads of family court is the Justice on Wheels project. Now, with this project, the Justice on Wheels, the goal here is to improve the access of the poor and marginalized sectors to affordable judicial services. The mobile court is in a form of a large bus staffed by a judge, a prosecutor, and a stenographer, and among others, the ad hoc committee on the Justice on Wheels project, which is headed by Justice Ascuna as chairperson and Senior Deputy Court Administrator Elepanio as vice chair. The case heard were for such crimes as light threats, illegal possession of firearms and deadly weapons, theft, robbery, and violations of PD 1619, which is a decree penalizing the use or possession of unauthorized sale to minors of volatile substances for the purpose of inducing intoxication. Now let's talk about enforcement of judgments and arbitral awards. Now the court may enter a satisfaction of judgment upon first return of execution satisfied, second, the filing of an admission of satisfaction of judgment executed and acknowledged in the manner as a conveyance of real property by the judgment creditor or his attorney. Third, an endorsement of such admission by the judgment creditor or his attorney on the face of the record of the judgment. And fourth, when the judgment is satisfied other than upon on execution, the court may order satisfaction of judgment without the judgment debtor complying with certain specified requirements. Now, the effect of a judgment varies. A judgment that is in rem, meaning the judgment or order is conclusive upon the title to the thing, the will, or administration or the condition, status, or relationship of the person. If it is in persona, the judgment is conclusive amongst the parties and their successors in interest by title subsequent to the commencement of the action or special proceedings, litigating for the same thing and under the same title and in the capacity. So again, if it is in rem, it is conclusive upon the title to the thing, the will or administration or condition, status or relationship. If it is in person, it is conclusive among the parties and their successor in interest. And the conclusiveness of the judgment wherein the parties are both acts to both actions may be the same, but the causes of actions are the same, is binding only with respect to the matters actually raised and adjudged therein. So, provided that a foreign tribunal has jurisdiction to promulgate judgments, the effects will also be as follows. This is for foreign tribunal. When actions are in rem, the judgment is the same, is conclusive upon the title to the thing. If it's actions in persona, the judgment is presumptive evidence of a right between parties and their successors in interest. Now, a judgment may be repelled by evidence of lack of jurisdiction, lack of notice to the party, meaning there was no service of someone, if there's collusion, fraud, or a clear mistake of law or fact. Now, except for labor arbitration, which is provided for by the Labor Code, the legal basis of arbitration is the contract of agreement between the parties to arbitrate future disputes or to submit to arbitration disputes that have already arisen. Under Article 1306 of the Civil Code, this guarantees such right when it provides that contracting parties may establish stipulations, clauses, terms, and conditions they deem convenient, provided that they are not contrary to laws, morals, good customs, public order, or public policy. So, meaning the contracting parties have the freedom to stipulate whatever they have in their contracts, so long as these are not contrary to laws and policies and good customs. Now, Section 2 of the arbitration law also recognizes arbitration agreements and arbitration clauses. By the broad language of the Section 1, it implies that any claim or dispute arising out of the contract or determinate the legal relationship may be submitted to arbitration. Now, some highlights. When the court is satisfied that the making of the agreement or the failure to comply with it is not an issue, the court shall order the parties to proceed to arbitration. So again, It is the default of the court to always try to find amicable settlement, especially if the contract of that party says so. Now, all acts of the parties subsequent to the making of the contract which raise issues of fact or law lie exclusively within the jurisdiction of the arbitrators. Now, usually a contract provides for the method of naming or appointing the arbitrator, but if there's no such method, the RTC shall designate the arbitrator, and they must be sworn by any officer authorized by law or authorized to administer an oath. Now, arbitrators may, at the commencement of the hearing, ask both parties for a brief statement of the issues in controversy and agreed statement of facts. Now, we have to take note that the arbitrators are the sole judges of the relevancy and materiality of the evidence. So when you say relevancy, it has a relation to the issue, and materiality, it is not in violation of certain law. So the evidence that are offered, and it's the arbitrator that tests if these are bound or not bound to conform the rules of the court pertaining to evidence. Now, briefs may be filed by the parties in 15 days after the close of the oral hearings, and unless the parties have stipulated by written agreement the time within which arbitrators may render their award, the written award is usually rendered 30 days after the closing of the hearing, and this can be extended by mutual consent. Now, at any time within 1 month after an award is made, any party to the arbitration may apply to the court having jurisdiction for an order confirming the award unless the award is vacated, modified, or corrected. An appeal may also be taken from the order upon award through certiorari proceedings, but those appeals are limited to questions of law only because usually it's the arbitrator who makes the judgment call. All right, that's it. A very brief discussion of some salient points in related to civil procedure. If you find this video substantial, don't forget to like, share, and subscribe. Thank you very much.